This is part 4 of the statewide residential purchase agreement, of which we'll be starting at line 378 and concluding in this section. Starting on 378, number 20, closing. This contract shall be performed and this transaction shall be closed on a date mutually agreed upon by the parties in writing, but in no event later than blank. This is where you'll insert a date. For purposes of this contract, the parties agree that the transaction will be considered to have closed when the following has occurred, initial only one. And in our office, I would like you to check line 381. All necessary documents have been signed by all required parties and the transaction is funded. Or blank, the date on which the following the execution of all necessary documents by the parties, the sale proceeds are dispersed to the seller. So 384, notwithstanding anything to the contrary, in the event that the buyer and seller are proceeding in good faith and the closing cannot occur due to any occurrence or circumstances out of the direct control of either party, except as reserved for title defects in paragraph 16E, deed and conveyance, the date of closing shall be extended for a period of up to 7 days. Unless otherwise agreed, such extension shall extend the terms of possession and occupancy by an equal number of days as closing was extended. The signatories below grant permission to the settlement agent to provide to their respective broker copies of the closing disclosure and the settlement statement prior to closing. Note, under paragraph 20, the parties may agree in writing as to when the closing will occur, but includes a place for a deadline to be inserted. In some areas of Ohio, escrow closings are routinely conducted instead of round-table closings. That is our area of Northeast Ohio. Because of regional differences as to when the closing is considered to have occurred, this paragraph was written to allow the parties to choose how they define closing. In the first option, the transaction is considered funded when all necessary funds have been transferred, i.e. wired, to the title agent. In the second option, closing requires signing of all necessary documents and disbursement of sale proceeds to the seller. Now, why I recommend 381 is because that's how we traditionally do it here. What's nice about this section is you may have buyers or sellers coming from other parts of Ohio who are used to closing as being different. This is going to show them the differences from areas and how they occur. Also, under line 381, the new language that we've interpreted now that since 2020, the year 2020, the title companies consider the properties funded when they've received all of the documents. They used to call you up and say the property is title transferred. Now they will tell you it's funded. If you're using a title company in our area that you're familiar with, regardless if you're using one that you're not familiar with, please always ask them if they as a title company have gap insurance. Gap insurance covers them what they need when they have your property funded. So please note that also. All right, moving on. Line 390, section 21, possession. Possession will be provided to the buyer according to one of the following checked options. At 391, at closing. 392, at such a time, AM or PM, on such a date. Insert it there, following the closing. On 393, insert the number of days after closing at what time possession will be given up. That might say 10 days at 6 o'clock p.m. That's an example of what that might say. 394. If the seller maintains possession of the property after closing, it is recommended that the parties enter into a post-closing possession addendum. The addendum is or is not attached. 396. If the seller fails to vacate as agreed in this contract or any attached post-closing possession addendum, the seller shall be responsible for all expenses incurred by the buyer to obtain possession. Note, in some areas of Ohio, it is customary for the seller to maintain possession after closing, often up to 30 days. Ohio Realtors provides an addendum for use in transactions in which the seller will remain in the property after closing. While not required to be used, it is highly recommended. Additional terms or conditions should be prepared by an attorney representing a party. So under 394, the addendum that they're talking about, we are utilizing it. It has replaced our previous document that was seller possession after title transfer, and we are now using it, and please check the box accordingly if you're going to use it. Line 398, Section 22, Property Maintenance. While the seller is in possession, the seller shall maintain the property in the same location, condition, and working order as the date of acceptance of this contract. Normal wear and tear accepted. This duty of maintenance shall include, but not limited to, the interior and exterior grounds and all structural and mechanical equipment, including all major appliances being conveyed. Line 401, Section 23. Debris and personal property. Property shall be broom swept clean, and seller shall remove all debris and personal property not included in this contract by the date and time of buyer's possession. If the seller fails to comply with this paragraph, any personal property debris remaining on the property shall be deemed abandoned, and the seller shall be liable to the buyer for all costs associated with bringing the property to broom clean condition and/or removal and disposal of the seller's personal property and other debris. Line 405. This replaces anybody's walkthrough addendum so that you know. Section 24. Final verification of condition. The buyer shall have the right to make a final verification of the condition of the property no later than blank days, 2 days if left blank, prior to the execution of closing documents to confirm that A, the property is in substantially the same condition as it was on the date of this contract, normal wear and tear accepted, or as otherwise agreed, and B, repairs, if any, have been completed as agreed. Line 408, Section 25. Damage or destruction of property. Upon discovery of damage or destruction of property, it is strongly recommended that the parties retain legal counsel. Line 410, 25A. Risk of loss to the property occurring prior to closing shall be borne by the seller. If any part of the property covered by this contract is substantially damaged or destroyed prior to closing, seller shall, within 2 days from the date of discovery, give written notice of the damage or destruction to the buyer and or buyer's broker. Such notice must include all pertinent information regarding insurance, policies, and claims, including the amount of any applicable policy deduction. Upon receipt of such notice, the buyer shall, within 10 days of receipt of the seller's notice, 1. Provide written notice to the seller or the seller's broker that the buyer accepts the condition of the property as damaged or destroyed and proceed to close. Line 416, number 2. Agree to proceed to close pursuant to a written agreement reached with the seller regarding the repairs, closing date, and or any compensation due buyer for damages, or 3. Provide written notice that the buyer is terminating the contract. Upon termination, any earnest money deposit made by the buyer shall be dispersed pursuant to paragraph 6 earnest money. Line 420, 25B. The buyer's failure to provide one of the notices provided above shall constitute an election by the buyer to terminate the contract pursuant to paragraph 25A, number 3, damage or destruction. 422, 25C. Failure by the seller to provide required written notice to the buyer and or the buyer's broker shall result in the buyer, upon discovery of the damage or destruction before closing, having all rights set forth herein. Note, paragraph 25 addresses the rights and obligations of the parties in the event the property is damaged or destroyed while the contract is pending. This paragraph provides the option for the parties to close pursuant to a written agreement regarding repairs, closing date, and compensation. If applicable, it is strongly recommended that brokers, upon being informed of such damage or destruction of the property, recommend to their clients that legal counsel be obtained. Line 424, Section 26, Home Warranty or Protection Plan. Buyer selects or does not select a home warranty be provided by the name of the company, home warranty company, and paid for by the seller or the buyer at an amount not to exceed the amount of the warranty. Broker may receive compensation for services rendered in connection with the sale of the home warranty. Line 427, Section 27, Ohio Fair Housing Law. It is illegal, pursuant to the Ohio Fair Housing Law, Division H, Section 4112.02 of the Revised Code, and the Federal Fair Housing Law 42 USCA 3601, as amended, to refuse to sell, transfer, assign, rent, lease, sublease, or finance housing accommodations, refuse to negotiate for the sale or rental of housing accommodations, or otherwise deny or make unavailable housing accommodations because of race, color, religion, sex, familial status as defined in Section 4112.01 of the Revised Code, ancestry, military status as defined in that section, disability as defined in that section, or national origin, or to so discriminate in advertising the sale or rental of housing, in the financing of housing, or in the provision of real estate brokerage services. It is also illegal for profit to induce or attempt to induce a person to sell or rent a dwelling by representations regarding the entry into the neighborhood of a person or persons belonging to one of the protected classes. Line 434, Section 28, Special Flood Hazard Area. Unless previously disclosed by the seller, it is buyer's sole responsibility to determine whether the property is in a special flood hazard area. If it is determined that the property is in a special flood hazard area, the buyer may terminate this contract by sending written notice to the seller by either 1, no later than 10 days following the date of acceptance of this contract if disclosed by the seller, or 2, by the end of the loan commitment period, if not previously disclosed. If the buyer fails to deliver such written notice, this contingency is waived. Line 438, Section 29, Electronic Wire Fraud. Email is not always secure or confidential. Never respond to a request that you send funds or non-public personal information such as your social security number, credit card, or debit card numbers, or bank account and or routing numbers by email. If you receive an email message concerning a transaction and the email requests that you send funds or provide non-public personal information, do not respond to the email and immediately contact the known individual entity with whom you have an established relationship using a separately verified method of communication to determine the validity of the email. 443, MLS and concessions. The parties authorize the broker to report sales information and financing concessions data to any multiple listing service and, upon request, to any state licensed appraiser researching comparable sales to the extent necessary to accurately reflect market value. Line 445, Section 31, Professional Advice and Assistance. The parties acknowledge and agree that the purchase of real property encompasses many professional disciplines. While broker possesses considerable general knowledge, broker is not an expert on matters of law, tax, insurance, financing, surveying, structural conditions, hazardous materials, environmental conditions, inspections, engineering, etc. Broker hereby advises the parties, and the parties acknowledge that they should seek professional expert assistance and advice in these and other areas of professional expertise. In the event the broker provides to the buyer or seller names of companies or sources for such advice, assistance, or services, including inspections or repairs, the parties additionally acknowledge and agree that the broker does not warrant, guarantee, or endorse the services and or products of such companies or sources. Line 452, Section 32, Indemnification. The parties acknowledge that the broker is relying on all information provided herein or supplied by the seller or the buyer in connection with the property, and agree to indemnify and hold harmless the broker from any claims, demands, damages, lawsuits, liabilities, costs, and expenses, including reasonable attorney's fees, arising out of misrepresentation or concealment of facts by the seller and or buyer. Line 455-33, Compliance with dates. Time is of the essence as to all dates set forth in this contract. This means the parties must perform by the dates provided in this contract. To be binding, any agreement to modify, extend, or waive any of the dates provided herein must be in writing and signed by all parties. Note, To avoid any ambiguity about the dates in this contract, paragraph 33 affirmatively states the time is of the essence as to all dates in the contract. This provision is an instruction to the parties, and if needed, a court of law, that all of the deadlines in the contract are be fully enforced unless the parties agree otherwise, and that agreement is in writing and signed by all parties. 458. Dispute resolution. In consideration of the terms and consideration as stated in this contract, the parties agree to mediate any dispute or claim arising out of this contract before initiating any legal action against the other party. In the event the mediation does not result in an acceptable resolution of the parties, then either party may initiate a legal action against the other party. Costs related to mediation shall be mutually shared between or among the parties. The mediation shall be held in the county where the property is located unless all parties agree otherwise. The mediator shall be mutually agreed by all parties and is recommended to be a retired judge or justice or an attorney or other professional with at least 5 years of residential real estate experience, unless the parties mutually agree to a different mediator. The parties cannot mutually agree upon a mediator. They will each select a mediator who will then jointly select a mediator to conduct the mediation. 465. Exclusions. The following matters should be excluded for mediation. 1. A judicial or non-judicial foreclosure or other action or proceeding to enforce a deed, mortgage, or installment land sale contract is defined in accordance with Ohio law. 2. An unlawful detainer action, forcible entry detainer, eviction action, or equivalent. 3. The filing or enforcement of a mechanic's lien, and 4, any matter that is within the jurisdiction of probate, small claims, or bankruptcy court. The filing of a court action to enable the recording of a notice of pending action for order of attachment, receivership, injunction, or other provisional remedies shall not constitute a waiver or violation of the mediation provision of this paragraph. Line 470, section 35, gives you the opportunity to add additional terms or conditions addenda. Note, the parties can include other additional terms or conditions that are not included in the contract or use this area to reference an attached addendum. 474, section 36, entire agreement, amendments to terms. The parties agree that this contract constitutes the entire agreement and no oral or implied agreement exists. The terms and conditions of any other addenda supersede any conflicting terms of this contract unless any addenda expressly state otherwise. Except as provided for in paragraph 2D, financing, any agreement to modify any terms of this contract must be in writing and signed by all parties to be enforceable. All provisions in this contract hereto shall survive the closing and delivery of the deed. This contract shall be governed by and construed in accordance with the laws of the state of Ohio without regard to principles of conflicts of laws. All disputes, controversies, or litigation that may arise between the parties must be brought in the county where the property is located. No waiver by the seller or buyer of any rights of the parties hereunder shall be deemed or construed to be a waiver of such rights with respect to the other or future actions of the parties. If any of the terms or conditions of this contract are for any reason held to be invalid or unenforceable, such invalidity or unenforceability shall not affect any of the other terms or conditions of this contract. Note, it is crucial that all agreements between the parties regarding real estate transaction be contained in the contract and any subsequent amendments or addendums fully signed and in writing. 483. Signatures. Only manual or electronic signatures of the parties on contract documents shall be valid for purposes of this contract, and any written amendments or required notices. For purposes of this provision, electronic communication, for example, but not limited to email messages or text messages made by a party or broker, are not considered terms of the contract and are not binding on the parties. This contract may be executed in one or more counterparts, each of which shall be deemed an original, but all of which together shall constitute one and the same instrument. Agents are increasingly negotiating the terms of contracts by text messages and emails, which often results in disputes between parties as to whether a contract has been formed and the agreed upon terms. The second sentence of this paragraph was included to clarify that emails and text messages made by a party or their broker are not terms of the contract and are not binding by the parties. Acceptance, which is line 488, section 38. This contract shall be accepted and binding upon each of the parties and their respective legal representatives, successors, and assigns when the final writing is signed by all necessary parties and is delivered to the offering party or their broker. Acceptances and any notices required under this agreement shall be provided by physical delivery or by electronic transmission and shall be effective upon delivery to the other party or their broker. It is strongly recommended that the delivering party verify that delivery has been received by the other party. Line 492, this is a new area that we haven't had in the past. Section 39, duration of the offer. This offer is open for acceptance until such and such date at time, unless withdrawn before acceptance. As a buyer, it is important to read and understand this offer before signing below. By signing below, buyer fully understands and approves this offer, is of legal age and capacity, has the authority to enter into this contract, and that any and all signatories, including that of a spouse or otherwise who are necessary in order to purchase a property or obtain lender financing, have agreed to sign such required purchase and or financing documents. Note, dower or other spousal rights may require signature of spouse even if spouse is not on loan or title deed. Line 498, buyer acknowledges that agreed upon written acceptance and delivery, this is a legal binding contract, and that if any provision is not understood, legal advice should be obtained. Let me just go back up to line 39, duration of the offer. It is not required that you as an agent use that section. So if your buyer is not interested in putting a time frame on it, it does not have to be used. By leaving it blank is absolutely acceptable. So under line 500, this gives you some other options we haven't had in the past. The very first line for signatures of a buyer is an entity if applicable, then the buyer's signature, and then the buyer's printed name. Note, for buyers signing as entities, such as LLCs or corporations, it is recommended that the entity name be printed on the entity, if applicable, line, followed by the signature of the authorized person on the buyer's signature line, followed by the printed name of the authorized person and their authorized capacity. Example, sole member, managing member on the buyer printed name and title of the applicable line. For trusts and POAs, it is recommended to use the signature and printed name lines to clearly identify the name and capacity of the signer. Line 501, Section 40, action by the seller. As a seller, it is important to read and understand this offer before signing. Seller represents that the seller read and fully understands this offer, is of legal age and capacity, and has the sole and complete authority to enter into this contract and to sell the property, and that the consent or approval of any other person or entity is not required. Line 504, this is a new area, so pay attention. Seller acknowledges that upon written acceptance and delivery, this is a legal binding contract, any of the provisions are not understood, legal advice should be obtained. By 506 to 508, we're giving the opportunity for the seller to select one of these choices. 506, the seller accepts the buyer's offer and agrees to convey the property according to the terms and conditions herein. So the seller accepts it as is, there is no counteroffer. Line 507, the seller rejects the buyer's offer. And line 508, the seller counteroffers according to the modifications attached as a counteroffer addendum or is modified herein via an electronic signature platform. The counteroffer is open for acceptance until such and such time and date. So, backtracking on line 507, if you're involved in a multiple offer and you've presented your offer to someone else representing the seller and they told you that your offer was not accepted, it is our policy in our office for you to then state, we understand that, thank you very much. Please have the sellers check or initial box 507 and sign the purchase agreement and the agency disclosure. Those are the documents our brokerage will require to prove that the offer had been received and reviewed by the seller. You can then make your buyer aware by giving them a copy of that so they also can see that that happened. And again, below 510, the same exact way applies for the seller as it did for the buyer, for the seller signing entity, who they are, and et cetera, et cetera. All right, under 511, release of dower. If seller is married and the seller's spouse is not a party to this contract, by signing below, the seller's spouse hereby agrees to sign a separate release of his or her interest in the property no later than the date of closing. Any questions regarding a spouse's dower interest should be referred to an attorney. Note, in some instances, a seller's spouse may not be on the deed as a title owner and may not wish to sign a contract as a seller. By signing under this paragraph, the non-title holding spouse is aware that the property is being sold and agrees to release their dower interest on or before closing to reduce the likelihood of conflict. Okay, then we have the seller's spouse's signature goes there, as well as our administrative purposes only, which is where the listing agents and their IDs go. Note, the above information is included in some local markets, typically as a convenience for the title company that will be closing the transaction. However, some markets do not include this section. This information is voluntary and could be included in a separate document for those who wish to do so. This concludes the document. I'd just like to make a couple of other notations for you, and that is that this is a copywritten document by the State of Ohio Association of Realtors and is not to be modified. What that means is you are not to add verbiage to it, language that would normally typically be in an addendum. You can strike through areas that might not apply if you so choose, but otherwise an addendum might be needed to be added. We honestly feel that we've addressed pretty much a lot of what might need a separate addendum. Of course, there's always situations that something else is needed. I'm always very happy to help you with any of those. Another thing is, this took a long time for us to go through. I appreciate your patience and your training on it. What I would like to say is that I hope that you learned a lot by these audio recordings, but in our brokerage, as the broker, I would like to make sure that you know that my recommendation every single time that you write an offer for your buyer or you receive an offer on behalf of your seller, that you read this to your client word for word. It's important for them to understand the document they're signing, as it's a legal binding contract, and for you to interpret what they might be confused by and answer any questions they may have. So it is our policy here, my recommendation as your broker, that you always read these word for word to your clients so they totally understand what they're committing themselves to. And last, I would also like to reiterate, as I have in the past in these other sections, that this training is for our brokerage at Keller Williams, Greater Cleveland Northeast, and that anyone else that may be listening in to do training for themselves, to please consult your own broker or manager if you have any questions or what your brokerage policies may be. Thank you very much.